Regarding Antonio McLaughlin, correct?
Correct, Judge.
Okay. My first witness.
Yes, Your Honor.
Want to make a statement? Go ahead.
Well, we weren't sure on the procedure whether the state calls the first witness. I know that this defense bears the burden of proof. So.
Well, it's Mr. McLaughlin's motion, and
So defense will go
I think
first.
he's got the burden to show that his attorney was ineffective.
Correct, Your Honor. So I'll call witnesses first.
Okay.
And Your Honor, may it please the court, Jennifer Flowers, for the record, on behalf of Mr. Antonio McLaughlin in 2018 CF 748. As the court stated, we're here on a post-conviction relief motion that was filed pro se by the defendant in this case, alleging ineffective assistance of counsel, and I am representing him in this portion of the case. Just to bring the court up to speed, I'm sure that I'll just briefly go over the procedural posture of this case. The defendant was arrested in March of 2018 and charged by information filed in April 2018 with burglary of an occupied dwelling, 1 count. It's a second-degree felony, level 7. He was appointed the public defender. At some point, the state had made an offer for 10 years with an HFO designation. This case was set for trial on November 5th and for trial to begin on the 13th of November. He was found guilty by jury on the 13th of November as charged. Pending sentencing, the defendant filed a pro se motion for ineffective assistance of counsel, and the court held a Nelson hearing on the 31st of January of 2019 and took testimony and took that under advisement and entered an order denying that motion on the 6th of February 2019. The defendant filed a second motion for ineffective assistance of counsel that was stricken because it was not signed. And so the defendant filed a third pro se motion for ineffective assistance that was signed and was granted for an evidentiary hearing, which we're obviously here for today. The pertinent records are court transcripts that are part of the court file, and I'm just asking that the court take judicial notice for purposes of this hearing, those transcripts. I won't be admitting them as evidence, but...
Any objection? I think that was actually, when I reviewed, they were attached.
Your Honor, and actually I filed a notice of request to take judicial notice as well. There was 10 items listed.
Right.
It should be all of the transcripts, including the letters that the defendant had written. They're all in benchmark. They're all uploaded, so I have no objection to the request. I'll be referencing those, and they're also the transcripts are referenced in the state's response.
And also, they would be the ones going forward with their hearing. Would you agree? Was there some dispute as to who has the burden?
Oh, it would be the defense's. It's the defense's burden. I don't get to say that very often, but it's the defense's
That's
burden here, and
okay.
so they get to go first.
And yes, Your Honor,
If something changed, I didn't perhaps.
No, Your Honor. In
Okay.
this case, the defense has the burden to prove the allegations in the motion by evidence. Today, in the form of testimony, there's two witnesses here today, the defendant and former defense counsel, Franz Chavans. So at this time, I would like to call Mr. Chavans.
And I'll take judicial notice of those transcripts.
Thank you, Your Honor.
Okay, come on up. Would you please remain standing and raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes.
All right, thank you. Be seated.
Trying to see, should I move over here so that I can see a little bit?
Sure.
Is that okay?
Yes.
Okay. Okay, good afternoon. Could you please state your name for the record?
Yes, Franz Chavans,
Okay. And where are you currently employed?
at the Will Lawyer in Destin, Florida, doing estate planning.
Okay. And where were you employed on or about October, November 2018?
At the Office of the Public Defender, First Judicial Circuit. I was located here in Crestview.
Okay. And do you recalling being appointed to and representing the defendant, Mr. Antonio McLaughlin?
Yes.
Okay. And when did your representation of Mr. McLaughlin begin?
I can't recall the specific date.
Okay. But sometime after his arrest in March of 2019?
Yes.
Correct, okay. March 2018. All right, did the state make an offer to resolve the case with a plea?
Yes.
Okay. And when did they make that first plea offer, do you recall?
Not the specific date. I don't recall when I received the discovery, and usually the offer is included in the discovery.
Okay. Do you recall what the initial offer was?
Upon reviewing some of the records, it was 10 years, but prior to reviewing the records, I couldn't remember what it was. I do recall that it was on the higher end.
Okay. It was a high offer?
It was a high offer, yes.
Okay. Do you remember if it was in writing?
Yes.
Okay. And did you convey that offer of 10 years to the defendant?
I conveyed the offer that I had, and if it was 10 years, then yes, I conveyed that.
Okay. And when you first conveyed the offer, did you advise him to decline the offer?
Could you, when you say first,
Like well, let me ask you this. About how many times would you say approximately that you met with Mr. McLaughlin prior to trial, between being appointed and trial?
not including times like prior to court in the holding, I'd say maybe 5 times, maybe more,
Okay.
more frequently as we got closer to the eventual trial date.
Of course. So when you first, do you recall the meeting when you first conveyed the state's initial offer? Do you recall the conversation that you had with the client?
I can remember some of it, but of course, specifically what was said, I'd be lying if I said I could tell you exactly what I said. But I do recall reviewing the file and then going over it with Mr. McLaughlin.
Okay. And did you advise him at any time of the statutory maximums he would be subject to if he took the case to trial?
Yes.
Okay. Did the state at any time make an amended offer?
If my memory may be wrong, I don't believe so. The only time that there was an amended offer or the offer change would have been on the eve of trial when it was removed and had gone up. So there was never a point during my representation when the offer got any better for Mr. McLaughlin.
And by any better, you mean any lower than 10 years DOC?
That's what I mean.
Okay. Did you tell the defendant, do you recall telling the defendant at any time that the state would make an amended offer?
I did not recall saying that. And I don't believe I said that. I can say that I'm always hopeful in trying to get offers, but I will never make a guarantee that the state would make a better offer because it's out of my control.
Of course, okay. Do you recall a conversation with the defendant at the jail on or about October 9th, 2018. I know that's a specific date, but it was approximately 1 month prior to docket day where the case was set for trial. Do you remember things would have been getting ready for trial at that point? Do you remember a conversation at or around that date?
As it relates to the date, no, but I do recall that we had a conversation on the eve of trial. I would say that around that time seems about right. If you give me some more details, I may be able to.
Okay. Do you recall advising the defendant to turn down the 10-year offer when you're referring to it as the eve of trial, when things were getting more heated and more ready for trial? Do you recall telling the defendant at that time or at any time to turn down the 10-year offer?
Yes.
Okay. And about when did you, why did you tell him to do that?
The reason why is because generally when I reviewed a case, and this is not just for Mr. McLaughlin's case, but cases in general, I would look to see what evidence the state would have and determine if I felt that there was enough prima facie evidence to support a conviction. And if I felt that there was, and that the offer that was being given was reasonable, I would advise my clients, hey, this would make sense, given the risk of trial and the potential for it to, get out of hand. In this specific case, I reviewed the case and I felt that there was a strong argument that we could make at trial, which is not very common a lot of times, not very common at all, to have a strong case at trial. And in this case, I did feel that we had a strong argument at trial, and based on the severity of the offer and the fact that based on our conversation, me and Mr. McLaughlin's conversation, he wasn't inclined to take it, I didn't seek to change his mind to accept the 10-year offer. So I agreed in that we should turn it down.
Okay. At what point did it become clear to you, and at what point did it become clear to you that the state was not going to budge or make any other offers?
Well, that's a hard question to answer because I don't know specific dates, but I can say usually once we set a case for trial, and as you may know, there's usually a series of continuances and things that take place, like deposition and those things. But once we set a case for trial, usually that's when I think would be the last opportunity for the state to change their mind. So setting a case for trial usually sort of forces the matter, and once we set it for trial and the state revoked the offer, then I knew at that point there wasn't going to be anything else. And of course, I knew prior to setting it for trial that the state would revoke the offer, and it would have been right around that that court date, right around that time.
Okay. So in that time when you said that you knew that the state would revoke the offer if he didn't take it, you're saying that at that time, did you advise him? Was it because you're a counselor, you're a lawyer, and he's not trained in evidence, in the rules of evidence and everything. Did you, at that time, advise him to decline the 10-year offer?
Yes, I would have advised him at that time.
And did you advise him at any time to accept the 10-year offer? Like eve of trial?
I would say no, and I can elaborate on that if you'd like.
Sure.
I felt that there was a defense that we could use at trial, and from when I received the case up until about picking a jury, essentially, just prior to the jury selection, nothing had changed about that. So I had no reason to instruct him to take the 10-year offer. If I had received information or evidence or something that would have jeopardized my theory of defense, I would have, of course, discussed it with Mr. McLaughlin. And then if I felt that it was a bad turn of events, I would have, of course, told him, hey, in light of these circumstances, we should change our mind. But nothing had changed, so I would have told him, if you're ready to go to trial, let's go to trial.
Okay. Were there any motions in limine heard by the court in this case that you recall?
Yes, there was.
Okay. And what did those specifically address?
Our theory of defense, the thing that I was hoping for a jury to consider.
And that was?
That was about, I thought, which was an important fact, that Mr. McLaughlin was highly intoxicated at the time that this offense occurred, and that my argument, which I believe is also on the record, was that it went to the intent of the defendant at the time as to whether he intended to commit a crime other than the trespass for the burglary, and I felt that he didn't. And I would be a poor counsel if I forced the client to accept a 10-year offer as a habitual felony offender when I felt that he was not guilty. But we're treading a fine line here, and when that motion in limine was granted on behalf of the state, it became clear that a jury would not be getting a full view of the facts that I thought were relevant in making a decision.
Okay. Do you recall, was that motion in limine heard but right before jury selection, or was it held on another day?
It was held right before jury selection.
Okay.
I believe so, and that's what my memory tells me, but I'm not certain as to whether that was, but it was just before jury selection.
Okay. Let me ask you this. After the court said granted the motion in limine in favor of the state, did you, at that time, was the 10-year offer still on the table? Was there an opportunity after the motion in limine for the defendant to accept the 10-year offer?
I don't believe so. I believe prior to getting to that point, the offer had been revoked. The only other opportunity that Mr. McLaughlin would have had would have been to plead straight up to the bench. Mm-hmm. And at that point, it may not have been 10 years. Could have been worse, could have been better, but it probably would not have been what the state had just previously revoked.
Did you ever discuss the option of pleading to the bench as an option, as a resolution to this case with the defendant? As
an option, but I definitely did not emphasize that, because again, my position was that there was a defense, and that if given an opportunity to present it to a jury, that we had an argument. And I would always go over with all of my clients, you can accept the plea, you can enter a plea of no contest and allow the judge to sentence you, and that the judge stays within a certain set of guidelines agreed upon by the level of the offense. And I don't recall having an in-depth conversation with Mr. McLaughlin that would have led to him thinking that that was the best outcome. If we did have that conversation, it would have only been after the motion in limine was granted. And at that point, I felt that there was a great risk in not even allowing a jury to make a decision at that point in lieu of the HFO status and the burglary of a dwelling.
Okay. And did Mr. McLaughlin ever say to you that he did not want to go to trial?
I don't recall him saying that, but I understand that with a lot of clients want to make sure that you're on their team and that they can count on you. And for a lot of people, they don't want to say, I don't want to go to trial, because they want to know somebody that's going to work their case and be prepared for trial in case a trial does happen. I don't recall him saying, I don't want to go to trial, and if had he said that, I would not have forced him into a trial, of course, because, the risk is very high.
Okay. Let's go back to, just to clarify your theory of defense, because you said that your strategic decision to go to trial was based on the fact that you had a belief that there was a defense. And the defense was that he was intoxicated?
Yes, and I believe I even used this example with Mr. McLaughlin. The way I pictured it is if, say you're on a college campus and college student goes out drinking one night and, gets intoxicated and stumbles into someone else's yard, someone else's house, sleeps on their couch, owner gets up and sees them, calls the police. Is that a burglary of a dwelling? I didn't think so. That'd be a trespass in my opinion. I think the fact that somebody is intoxicated speaks to their mental state as to whether they formulated the intent to commit a crime other than the trespass. Without evidence of the intoxication, it would just look like a college student just went into a house. Why else would they be in there other than to commit some crime? So it pulled the legs out from underneath the defense.
Well, were you aware prior to developing that as your theory of defense that involuntary or voluntary intoxication is not a defense to the intent element of crimes?
Yes, and my argument was that this was a specific intent crime that really hinges on the mind state of the defendant. And in some crimes, I think voluntary intoxication could not be a defense. But when it comes to the mental state of the defendant, I don't think it is a defense of the crime, but more a statement of fact.
Right, okay. And let me ask you this way, and this is in hindsight, but if had the 10-year offer been put back on the table after the conclusion of the motion in limine that eliminated your theory of defense, if that 10-year offer would have been on the table, would you have encouraged him to accept, or do you recall encouraging him to not accept?
Had the offer still been on the table and I knew that the evidence that I wanted to present was not going to be admissible, then I would have had a hard conversation with him. I would have said, I think it may be worth it. Here's why. Worth it to accept that offer. Because, I mean, I felt that's where the case hinged.
But you don't remember having that conversation with him because you don't remember that still being an offer on the table?
That's correct.
Okay. Did you at any time tell the defendant that the state's case was, quote, weak?
Yes.
Okay. And why did you say that?
Because again, I felt that based on the depositions that we did, based on the facts in the affidavit stating that nothing was taken, there were no threats made, nothing was broken, that it was a trespass. Maybe I was hopeful in thinking that, but I felt that the state's position in establishing a mental state of an intent to commit a crime would require some evidence to support that, and that would be circumstantial evidence largely, outside of the defendant testifying, but I felt that without any evidence to support the mental state, the mere fact that he was in the vicinity, in the vehicle, I felt it wasn't enough, that alone, especially in light of the intoxication.
Did you ever like go and print the jury instructions, specifically the elements of burglary, and go over those elements of burglary with the defendant?
Yes.
Prior to trial, okay. And did you advise him that the state could or could not prove those elements?
I advised them that I felt that the state would have a hard time and that we could make an argument for a jury to decide as it relates to the intention, the mental state.
Okay. Did you explain the implications of the HFO designation prior to trial?
I did, and it's something that if I explain it once, it may not stick, but that is something that I did explain.
Okay. Did you explain it once or more than once?
I couldn't tell you how many times, but I do know that I at least once had the conversation as to what habitual felony offender status would mean.
Okay. And do you think he understood?
To the best of my knowledge, yes, but I don't know.
Okay. Did you advise the defendant that there was video evidence showing him shortly thereafter committing the alleged burglary?
can't recall. I don't know. I didn't review any video footage, so I don't know if there is video of that, but I can't recall if I did. If there was video evidence that was made available to me, I would have gone over it with my client. I didn't hold back anything.
Okay. Do you specifically, but you don't specifically remember watching a video with your client at the jail?
I can't recall. I mean, it's possible. I don't know if it was a body camera footage, but I don't know if I did.
Okay. If there was video evidence, would you consider that an important piece of evidence?
As it relates to the trial, of course, because it's something that I would want my client to see, but as it relates to the defense, I believe that the footage, if there was any footage, I believe it was body camera footage, if I'm not mistaken. If there was any, it would have been body camera footage. I don't recall seeing anything else, but I would have shown it to him, absolutely, or had my investigator go in and present it to him.
Okay. That's your usual practice, is to do that?
If not me personally, then yes, my investigator.
Okay. But just to be clear, you don't specifically remember doing that with Mr. McLaughlin?
I don't recall if there was video footage, but yes, to answer your question, yes, I don't specifically recall, but that is because I don't recall if there was video footage. If there was, then I recall.
Okay. Do you have any written records showing that you discussed any of the above that I've just referenced with the defendant? Did you have him sign anything, or was there any documents, any documentation that you have with you today or that exists that would show that you guys went over these things?
There may be something on the file at the PD's office, but I don't have any documents with me.
Okay. So what was your defense at trial? Did you call any witnesses? Did you offer a defense?
I haven't reviewed the transcript, so I'd want to see what the only other witness that would have been called would have been Mr. McLaughlin. I can't recall if we decided to call him to the stand or not.
Okay.
But the argument was essentially that it was the same minus the intoxication.
Okay. Was he aware prior to trial that you guys wouldn't be able to argue the intoxication pursuant to the motion in limine ruling?
Yes, when I found out about that, I told him. Now, whether it was, depending on when the motion in limine had, it would have been at the next opportunity that I had to speak to him, I would have told him that.
Okay. Okay. And do you believe that the court would have accepted the 10-year plea agreement had the defendant signed it?
Objection calls for speculation.
Is there any? Do you recall any? Do you recall anything out of the ordinary that would lead you to? Well, that's speculation too. In your career, did the judge give you any reason to believe that he wouldn't accept a plea agreement between the parties?
Based on my experience, I know that whenever I set a case for trial and the state attorney puts on the record that an offer is revoked, I don't expect that a judge in receiving a plea to the bench would do less than what the state was offering, or even the same. Of course, as I would say now, as I would say then, I'm hopeful that a judge would do something like that, but I would not count on it getting any better than a revoked offer from the state.
But prior to the state revoking the offer, during the time when you were appointed up until, let's say, October, pre-trial, when, I believe at October pretrial, the offer was announced again on the record. Did the judge give you any, and the court give you any reason to believe they wouldn't accept a negotiated plea prior to the state revoking the offer?
Well, the court certainly didn't give me any indication that they would not accept it, but based on the nature of the charge and the habitual felony offender status, I wasn't confident that whatever plea to the bench that would have been made would have been better.
Correct, but I'm asking about a negotiated plea. Like, had the state made a 10-year offer in writing at some point early on, correct?
Yes.
And if the defendant had accepted that plea and they had offered a negotiated plea for the court to accept, do you have any reason to believe that the court would not have accepted that plea? I
understand what you're saying. No, I don't have any reason to believe that the judge would have denied a negotiated plea.
Okay. And do you recall? And eventually, you guys went to trial, correct?
Yes.
And Mr. McLaughlin was found guilty, correct?
Yes.
Okay. And what do you recall was the sentence that was imposed by the court? Do you recall?
In reviewing the transcripts briefly prior to this hearing, it was 20 years Department of Corrections and 3 years of probation to follow, I believe.
Okay.
But it was more.
Okay. Okay. I think those are my only questions. Thank you.
Ms. Glisson?
Thank you, Judge. Good afternoon.
Good afternoon.
You were with the Public Defender's Office for approximately 8 years, is that right?
7.
7 years. Throughout your career at the Public Defender's Office, is it fair to say you probably handled over a few thousand cases?
Yes.
Okay. So at the time that you were representing Mr. McLaughlin, you had already had a few thousand cases under your belt that you had resolved one way or the other. Is that right?
Yes, that's correct.
And did you represent Mr. McLaughlin in this case throughout pretty much the entirety of the trial until after the verdict?
Yes.
Okay. Now, prior to the trial, you said that the state had offered 10 years DOC with a habitual felony offender designation. Is that right?
I said that, yes.
Okay. And that offer was actually put on the record by the assistant state attorney quite a few times prior to the actual trial date, right? The offer was conveyed in court several times.
Yes, but I'm just relying on what the record says. But do I have independent knowledge of the number of times or more than once? I don't, but it's customary that it would have been.
And you had an opportunity to review the transcripts from this case, is that correct?
Yes.
Okay, and so you saw throughout the transcripts here and there a 10-year offer was made, and then several times a declination of that offer was put on the record.
Yes.
Okay. And then also, were you able to review the transcript where the prosecutor actually revoked the offer from September 4th of 2018?
Briefly, yes.
Okay. Now, before that offer was revoked September 4th of 2018, did Mr. McLaughlin ask you to make a counteroffer to the prosecutor?
Yes.
Do you recall what that offer was?
There were at least one, possibly 2 times. One was a guideline sentence, and that's pretty standard. Whenever I would go over an offer that was above guidelines for a charge, client would ask, why isn't it the guidelines? And then in addition to that, he asked me to specifically ask for a straight jail time on a trespass, which would have been 11 months, 29 days in jail, county jail.
And you conveyed those counteroffers to the prosecutor, correct?
Yes.
And did the prosecutor accept either of those counteroffers?
No.
Okay. Now, when you were prepping this case for trial, did you reviewed the evidence with him, correct?
Yes.
Okay. And you mentioned you met with Mr. McLaughlin at least 5 times.
Yes. To
prep for trial and kind of really dig in and have meaningful conversations about his case, right?
Well, I would say half of those times would have been prior to us really setting it for trial. The last couple of meetings would have been trial preparation, right before the date that we would have set it for trial, after we set it for trial, to touch base about what took place in court, and then on the eve of trial, just, what to expect.
Okay. And you had mentioned earlier that the main things that you were really hoping to use as the defense would be the intoxication and the fact that this was a mere trespass versus a burglary, meaning really the only difference there is the intent, right?
Yes.
Okay, and you had several conversations with him about that issue, right, of the trespass versus the burglary.
Yes.
Okay, so is it fair to say trespass was the defense when you actually went to trial?
Well, yes, it was without the intent, essentially, that the state could not prove that.
And Mr. McLaughlin, he agreed with you to go forward on the theory of this wasn't a burglary, this was just a trespass. He agreed with your theory of defense, correct?
Yes.
All right. And in fact, there was a transcript, the court's already taken judicial notice, from November 13th of 2018, which was jury selection. On page 6, the court says, Mr. Shivanis, during the course of the trial is going to suggest to the jury that you may be guilty of trespass. Do you understand? And the defendant says, quote, yes, sir, unquote. And then the court says, quote, does he have your permission to do that during the course of the trial, end quote. The defendant says, quote, yes, sir. Does that sound correct?
Yeah.
Okay.
Yes.
So Mr. McLaughlin put on the record that he was in agreement with your theory of the defense of going forward with a trespass, and this was after the motion in limine had been heard, excluding the involuntary intoxication.
Yes.
Okay. And I know you said earlier you thought whenever the offer was conveyed at the 10 years, considering the facts of the case, you personally thought, and you discussed with your client, that offer felt a bit high. Right?
Very high, but yes, that's
Okay.
right.
And did Mr. McLaughlin agree with you that he also felt that offer was high?
Yes, he agreed.
And did you at any point force or threaten Mr. McLaughlin into declining the 10-year offer?
No.
Okay. Did you, at any point, did Mr. McLaughlin tell you that he wanted to plead to a burglary at all?
No.
And he never told you that he wanted to accept the 10-year offer at any point?
No.
Even after he knew the motion in limine was ruled against him, correct?
I don't recall specifically after that, but I don't recall him ever saying that he wanted to take the offer at any point.
Okay. And as part of your job as a defense attorney, when you were practicing for criminal cases, did you advise your defendants of the strengths and weaknesses of the case?
Yes,
Okay, and did you do that with Mr. McLaughlin?
I did.
Okay. And did you advise him that there could be a possibility that he gets acquitted?
Yes.
All right, and did you discuss with them there's a possibility they could find him guilty of just a trespass?
Yes.
And also the fact that they could find him guilty as charged?
Yes.
Okay. Did you ever tell him at any point that an acquittal was guaranteed?
No.
Or a lesser included offense of trespass would be guaranteed?
No, I don't like I don't do guarantees.
And so it's fair to say part of your practice, you would never guarantee a defendant any result?
Never.
Was it fair to say that based on the amount of experience that you had throughout your career when assessing this case, you used your best judgment that you had learned throughout your professional career when advising him of strategies and defenses to this case?
Yes.
And September 4th of 2018, that was, according to the transcript, that's when the prosecutor had revoked the offer on the record. And also, all counteroffers had been made by that point, right? So as of September 4th of 2018, there was no other negotiations that had been ongoing.
I would say yes, but I would also add that even after a state revokes an offer, I still try to, see if the state's willing to reconsider things.
Sure. And actually, so the morning of the trial, after the offer was revoked on September 4th, there were several court hearings, and at each court hearing was that Mr. McLaughlin's position as well, that he still wished to proceed to trial, and he did not want to accept any type of offer.
As my understanding was, yes, I can't speak for what he was thinking, but there was no indication that he provided to me that he did not want to go to trial.
Okay. And do you recall on the date of jury selection, which was November 13th of 2018, you told the court after speaking with Mr. McLaughlin that he wanted to go forward with trial and to exercise his constitutional right to a jury trial, and the court asked Mr. McLaughlin specifically, is that correct? And Mr. McLaughlin responded, yes, Your Honor. Do you recall that in the reading in the transcripts?
Through the review, yes.
Okay. So ultimately, who made the final decision whether or not to proceed to trial or accept the state's 10-year offer?
Mr. McLaughlin did.
Okay. I don't have any other questions, Judge.
Can you redirect?
Just a couple things that I forgot to mention. Did you discuss an eyewitness ID as part of the discovery as a piece of evidence in the case? Do you recall discussing that?
I believe so. Again, if it was part of the discovery, we went over it, and that would have been the victim in the case, identifying him.
Mm-hmm.
If that's what you're referring to. I don't recall if there was any other like photo lineup or anything along those lines.
Okay. Okay, I think that was the only thing I didn't ask. Thank you.
No.
All right. Thank you. Sit down.
The defense would call Mr. Antonio McLaughlin, witness.
Is he excused?
If I'm excused, but I'd like to just.
Sure.
I'd like to, if he's going to stay, I'd like to just keep him here.
All
under
right.
subpoena.
Okay. All right, Mr. McLaughlin, would you please raise your right hand and be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes, ma'am. Yes, sir.
Okay, have a seat. All right, go ahead.
Good afternoon. Could you please state your name for the record?
Antonio McLaughlin,
Okay. And what's your date of birth?
11/9/81.
Okay. And are you the named defendant in the state of Florida versus Antonio McLaughlin? Is it McLaughlin?
McLaughlin.
McLaughlin, sorry about that. In case number 18 CF 748? Are you the named defendant in that
Yes,
case?
ma'am.
Okay. Were you arrested on or about March 19th, 2018 and charged with burglary of a dwelling?
Yes, ma'am.
Okay. And did you remain incarcerated from that time of arrest in March until the trial later that year, November?
Yes, ma'am.
Okay. And were you appointed counsel to represent you in the matter?
Yes, ma'am.
Okay. And who was your appointed attorney?
Some Francis.
Mr. Chavans?
Yes, ma'am.
Okay. Do you recall your first meeting with Mr. Chavans?
I don't remember the date.
Okay. Do you recall him conveying a pretrial offer from the state in this case? You don't recall him conveying any offer?
No, ma'am.
Okay. Were you aware that there was an offer made by the state to resolve your case with a plea for 10 years?
Yes, ma'am. He did. He definitely came up there with 10-year offer for 10 years from the state.
Okay, so you do recall him conveying a 10-year offer
Yes,
to you?
ma'am.
Okay. And when you discussed that 10-year offer, Did you have an opinion as to whether you wanted to accept the offer or proceed to trial?
I definitely want to take the 10.
You
I
didn't want to
definitely-
take the 10 years?
No,
Okay.
no, ma'am.
And did Mr. Chavans advise you whether that offer was reasonable or a good offer?
No, he definitely, yeah, he said it wasn't right.
He said it wasn't right.
Yeah,
Okay. Like that it was not a good offer.
not a good offer.
Did he advise you not to accept that offer? Okay.
Yes, sir.
So, did you ask Mr. Chavans to make any counter offers to the state?
That was, for one, yeah, it was 11/29, and I think the second one was, I think, somewhere like 3 years probation or something like that. It was somewhere in probation. I know that for a fact.
Okay. And to your knowledge, did Mr. Chavans make those counter offers
I
and
don't know if he
negotiate on
did
your
or
behalf?
not. I mean, I don't know if he did or not. He never told me that he did.
Okay. Did Mr. Chavans at any point convey an offer other than the 10 years DOC with HFO designation?
No, ma'am.
Okay. And about how many times did Mr. Chavans meet with you prior to trial that you can recall?
Maybe once before trial, he came up there and told me about it. But other than that, no, he definitely didn't do that.
But during his representation, did he, from when he was first appointed, did he meet with you before trial, like over the months leading up to the trial?
I don't think he did. I can't remember if he did or not.
Okay. Did you discuss the facts of your case with Mr. Chavans?
A couple times.
Okay. Did you discuss the score sheet?
We definitely didn't do that.
Okay. Did you discuss what the designation of habitual felony offender meant?
I think he did.
Okay. Did he advise you of statutory maximums that you would face if you were to go to trial and be convicted?
No, ma'am.
Okay. And by that I mean the amount of time that you could get in prison or on
No, ma'am.
probation.
It was strictly for 10 years and 10 years on. It wasn't nothing else on the table, none of that.
Okay. But did you discuss, I know that you're saying that that was the only offer on the table was the 10 years.
Mhm.
Did you discuss that if you went to trial that you could be subject to 30 years?
No, ma'am.
You didn't discuss that,
No,
that you
ma'am.
recall? Okay. Did he ever describe the 10-year offer as favorable or reasonable at any time?
No, ma'am.
At any time, did he advise you to accept the 10-year offer?
No, ma'am.
Okay. Did he advise you at any time to reject the offer?
The first time he came out there with the 10 years, I rejected off the rip. I mean, I didn't want to take it, period.
Yeah,
I
you
mean, he told me, I mean, yeah, he said, eventually he said out of his own mouth, said that we don't need to take this 10 years.
Okay.
I think I can beat this case. First thing he said out of his mouth. He said out of his
Okay, Mr. Tran said he could beat the case.
Yes, ma'am.
Okay. And what is your, before you were in prison and in the judicial system, did you have a job?
Yes, ma'am.
What did you do?
I was working on a roofing company.
Roofing?
Yes, ma'am.
Okay. Do you have any experience with the legal system other, like, and by that I mean, have you taken any classes? Do you have any legal education of the court
GED.
system? A GED?
Yes,
Okay.
ma'am.
But no specialized training in
No, ma'am.
the court system? Okay. Did you want to take this case to trial?
No, ma'am.
Okay. Did you tell Mr. Chavans that you did not want to take the case to trial?
Yes, ma'am.
Okay. How many times?
First time he came out there with the 10 years.
Okay. Did Mr. Chavans ever discuss the possibility of an open plea to the court as a resolution to this case?
No, ma'am.
Okay. Were you made aware that there was that there was video evidence in your case? A video?
I don't think so, he did.
Okay.
I don't think so.
Okay, so you never watched a video?
No.
Do you recall if a video was admitted during the course of the trial?
Yes, ma'am.
It was?
I mean, it was fit on the trial. That's the only time I seen it, when we seen that trial.
Okay.
That's it.
Okay. So Mr. Chavans, did Mr. Chavans or anyone ever show you that video evidence prior to trial?
No, ma'am.
Did you ask to see it prior to trial?
I don't think I did.
Okay. Were you aware of a witness, the victim, the named victim in the case, making an identification, making your ID in this case? Did you discuss that with Mr. Chavans?
No, ma'am.
Do you recall ever going over the elements of proof of burglary?
What that mean?
Like, the elements of proof of burglary being the one that's contentious in this case would have been the intent element.
No, man. Only thing that really it was supposed to have been a burglary and occupied dwelling, and then I believe he came up there with the states talking about that they changed the charge with burglary of the dwelling.
A burglary of a dwelling.
Yes,
Okay.
ma'am.
So, were you aware that Mr. Chavans, did he discuss with you his theory of defense, being that you were intoxicated and that would negate your intent, or? I
mean, he did, but then, like he said, like he just said, they rejected that, and they didn't even bring it up in court. Every time he said something about it, rejected.
Okay.
Yes.
So, but before they ruled that they couldn't talk about that, was your understanding that that was going to be your theory of defense? Was that you were intoxicated and so therefore you couldn't form the intent?
That's the only thing he really talked about at trial. He didn't really say too much, nothing else that I know of.
Okay. That was, okay. And did you agree to that being your defense?
Not necessarily. No, I didn't.
Okay.
Let me take a brief recess. I've got an emergency injunction I got to fill out, and then we'll come right back.
Sure.
Okay.
All rise, please.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Tackle Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
To the point, why didn't you, what was your reasoning behind not accepting the 10-year offer?
Because he said don't take it.
Okay. Had defense counsel advised you before trial to accept the 10-year offer, would you have accepted it?
I wanted to accept the 10 off the rip. Well, I told him I wanted to sign when you first told me.
Okay.
He said no.
If you had seen the video prior to trial and your defense counsel had discussed the video and the evidence and advised you to take the 10-year offer, would you have accepted it?
Yes, ma'am.
Were you ultimately found guilty at trial?
Yes, ma'am.
And what sentence was imposed?
I think burglary.
Well, how many years did you get?
I think they said they gave me 30 years, 20 years of state and 10 years papers.
Okay. 20 years DOC, 10 years probation.
Yes, ma'am.
Okay. Those are my only questions. Thank you.
Yes, ma'am.
All right, Ms. Gleason?
Sure. Hi, Mr. McLaughlin.
How you doing?
I'm all right, thank you. You said I couldn't really understand if you said you would have signed for 10 or you wanted to sign for 10 and your attorney said no.
I wanted to sign for 10.
You wanted to sign for 10?
Yes, ma'am.
Okay, and was that prior to starting jury selection? You wanted to sign for 10 years?
Way
DOC?
before that. It was way before when
that.
he came.
Okay.
When he came up to jail with the 10 years.
Okay, so you were wanting to plead to the burglary of a dwelling for 10 years DOC, right?
Yes, ma'am.
Okay. Well, do you remember writing a letter to Judge Flowers on December 14th of 2018 where you said that you admitted you had trespassed on another person's property and for that you were sorry? You remember saying that? Okay.
Yes, ma'am.
And December 14th, 2018 is actually after the guilty verdict had already been rendered, right? Okay. So then you continue in your letter, do you remember saying, but you had absolutely no intention of burglarizing anything, and furthermore, I believe my attorney failed me by not offering me the 43 months prior to trial. You remember saying that? Is that a yes?
Yes, ma'am.
Okay. And then you also say, but even now, I think that 43 months is a bit much for trespassing. You remember saying that?
No, ma'am.
Okay. If I showed you your written letter, would that refresh your memory? Okay. Your Honor, I'm going to approach with the defendant's letter from December 14th, 2018 as entered into benchmark, which judicial notice has already been taken. You see. Did you get to read that? Okay. And after reading that letter, do you recall writing, but even now I think that 43 months is a bit much for trespassing? Is that a yes? You have to verbally say,
Yes,
sorry,
ma'am.
we're being recorded.
Yes,
so
ma'am.
you do remember saying that. Well, so after the verdict, you were still thinking this was a trespass, right?
Yes, ma'am.
Okay. So if you still thought it was a trespass, and it's your testimony today that you were still willing to plead to a burglary?
I mean, that's coming from a lawyer, though. I mean, that's the only reason why.
No,
it's
sir,
right
this
here.
is coming from you. I'm talking about
Not
the letter
before
you
that.
wrote.
Not before that.
Okay.
Because, not before that.
Okay. Do you remember you rejected the offer on the record prior to trial? Do you remember that? You said you didn't want to take the offer and you wanted to go to trial.
I never said that.
Okay. So I'll go through your transcripts. Let's see. So on the trial date, well, the jury selection date of 2013, do you remember being asked by the court if you wanted to exercise your constitutional right to a jury trial?
I don't remember.
Okay. So if it's in the transcript from the date of your jury trial that you were asked, after your attorney said that you wanted to exercise your right to a jury trial, the court asked you, Mr. McLaughlin, is that correct? And you said, yes, Your Honor. Do you believe that you said that?
Yes, ma'am.
Okay. So that would be you wanted to go to trial, right?
After that, this is before he said, go on trial.
Okay.
I remember before he got there, I didn't want to go to trial. All of this right here is not, I didn't want to go to trial at all, period. He wanted to go to trial, not me.
Did you ever say to the judge you didn't want to go to trial?
No, ma'am.
Okay. And you also wrote a letter from January 15th of 2019, which was also well after the verdict. Do you recall writing a letter? It's called Motion of Ineffective Assistance of Counsel, and That's also judicially been noted. Notice has been taken from the letter of January 15th, 2019. Do you remember writing a letter to the court?
Yes, ma'am.
Okay. And you said on October 9th of 2018, defendant, Mr. McLaughlin, was advised not to take the offer that was offered to the defendant by or from the state attorney. Do you remember saying that? I need you to answer out loud because we're being recorded. Was that a yes or no?
Say that again.
You just have to answer out loud. So do you remember saying in your letter, October 9th on 2018, the defendant was advised not to take the offer that was offered to the defendant?
Yes, ma'am.
Okay. You specifically put a date in there. October 9th of 2018, you were advised not to take the offer, right? Okay. That's a yes?
Yes, ma'am.
Okay. But October 9th of 2018, that is already after the offer had been revoked, right?
I guess so.
Okay. Well, the transcript says from September 4th of 2018, the offer was already revoked. But your letter indicated that on October 9th specifically, which would have been after the offer was revoked, then you were advised not to take the offer. Is that what you're saying? There's no other dates listed, I guess is what I'm asking you. There's no other dates listed that you're saying your attorney advised you not to take the offer. October 9th, 2018 is a specific date that you remember, correct?
Whenever the date that he came up in county jail with that offer, I can't remember what day it was, so.
All right. And whenever your case was called up before trial, it was put on the record from the prosecutor that you were a habitual felony offender, which is HFO, right? And your maximum exposure was 30 years. Is that a yes? Are you shaking your head yes or no? I'm sorry.
No, ma'am. Don't remember.
Okay. How many times did you tell your attorney that you wanted to accept the 10-year offer?
Once when he first came to the county jail with that officer from the state.
So right out the gate, you said, I want to take it?
Yes,
I want
ma'am.
to sign for it?
Yes, ma'am.
Okay. And he told you no?
No, ma'am. Told me no.
He said absolutely not?
No, don't take it.
Okay. And if you wanted to take the 10-year offer, why would you have wanted to make a counteroffer of 1129 jail?
That was way before the offer even came to the county jail. I mean, this is way before he asked him to go on a trial. I've been, like I said, I asked him for that, and I asked him for 3 years probation way before he even talking about going to trial. This is
Mr.
way.
McLaughlin, you just said the very first time he brought you an offer of 10 years, you said you wanted to take it.
From the state.
You said you wanted to take it.
Yes, ma'am.
So if you wanted to take that, it was your idea to offer the 1129, right?
This is way before. Yeah,
Well, you said the first time that he met with you, you said you wanted to take the 10-year offer. So the 10-year offer was made, and then you wanted to take it, but he said no. Is that right?
Yes, ma'am.
And did he threaten you to say, no, you're not taking it? Or?
No, I mean, I guess he feel like, I think he feel like he can beat it in trial, I believe.
Okay. And you agreed in court on the record that you were okay with the theory, the strategic defense of a trespass, right?
Yes, ma'am.
And he never guaranteed you would be acquitted, right?
I can't remember.
Did he guarantee you that a jury would give you a trespass?
No, ma'am.
Okay. Okay, I don't have any other questions, Judge. Just briefly.
Mr. McLaughlin, the prosecutor asked you about the first letter that you had written to the judge.
Yes, ma'am.
Where you had, she spoke about that you still think that 43 months is a little high for a trespass.
Yes, ma'am.
Right? And she refreshed your recollection. You remember
Yes,
saying
ma'am.
that? Did you believe that you were not guilty of burglary and guilty only of a trespass because that's what your lawyer told you?
Yes, ma'am.
Okay. And referring to the transcripts, when you replied, "Yes, Your Honor," to the question of whether you wanted to go to trial, did you reply, "Yes, Your Honor," because that's what your lawyer advised you to do?
Yes,
to go
ma'am.
to trial?
Yes, ma'am.
Okay, thank you.
All right, he can step down. Thank you, sir. Next witnesses.
I have no other witnesses.
No witnesses from the state.
All right, I'll review everything and take it under advisement and get you out in order as soon as I can.
The argument? Just the argument is, may I make a brief?
Oh, I'm sorry, I thought you said nothing else.
Oh, I'm sorry, I have no other witnesses, but I have a brief argument.
Okay.
If I may just,
All right. Yes.
okay, that I prepared, okay. Your Honor, just to summarize what we've heard today in the testimony, Mr. Antonio McLaughlin was prejudiced in this case because he was denied effective assistance of counsel. And effective counsel claims under Florida Rule of Criminal Procedure 3.850 have two components. I won't list those, they're in, I know Your Honor is going to review the motions that have been submitted. But specifically in the context of a rejected plea offer, I just want to highlight that the court must consider having to stand trial, not choosing to waive it, as the prejudice alleged. In these particular cases involving a rejected plea offers, the defendant must satisfy three prongs, as stated in the pro se motion. The plea offer would have been presented to the court. Otherwise, that the defendant would have accepted the plea offer and the prosecution would not have withdrawn it. 2, that the court would have accepted its terms, and 3, that the convictions or sentence or both under the offer's terms would have been less severe than under the judgment sentence that were in fact imposed. And I just briefly want to go over the testimony that satisfied those prongs. To satisfy the first prong, the testimony of the defendant, Mr. McLaughlin, today is that he would have accepted the offer if counsel had advised him correctly. Defense counsel told Mr. McLaughlin to reject the offer, so that's what Mr. McLaughlin did. Defense counsel misadvised the client that the state's case was weak and told him that he could beat the charge at trial. Defense counsel has admitted to advising McLaughlin to reject the 10-year offer made prior to trial. Defense counsel did not show the video of the defendant prior to trial and did not discuss eyewitness ID prior to trial. And I just want to point out one thing that wasn't alleged in the motion, that was the pro se motion that was submitted, that came up in testimony today. Defense counsel's testimony today is that his theory of defense up until the eve of trial was that the intoxication would negate the element of intent, and that was what was the driving force to set this case for trial, was that this element of intent could not be proven due to intoxication. However, it is a well-established rule of law that defense counsel should have recognized that voluntary intoxication is not a defense, and to rely on that up until the eve of trial and allow an offer to be revoked based on a theory of defense that was very obviously not going to be allowed to be presented at trial was also a reason to find that he was not functioning as counsel guaranteed by the Sixth Amendment. To satisfy the second prong, that the court would have accepted its terms, the testimony today was that there was no indication that the court, to suggest the court would not have accepted the terms of the plea had it been negotiated prior to the revocation of the offer. The state even brought up several times the court inquired as to whether the parties had reached a plea agreement prior to the trial, and that offer had been put on the record several times, so that prong is satisfied. The third prong being that the conviction or sentence would have been worse. He's worse off now than he would have been had he taken the offer. And the testimony today was that the state's 10-year pretrial offer was obviously a lot less than the actual judgment and sentence that was imposed, which testimony today was that it was 20 years DOC followed by 10 years probation. So based on the testimony here today and everything raised in the motion, we would ask this court to grant the motion for post-conviction relief and vacate his judgment and sentence. And that's all. Thank you.
And Your Honor, the state's going to mostly rely on the response that's already been filed. However, I would like to put on the record the case law that's been provided to the court for consideration. That's going to be Alcorn v. State, 121 Southern 3rd, 419. Hunter v. State, 206 Southern 3rd, 839. Waite v. State, 212 Southern 3rd, 1082, and Madenza v. State, 81 Southern 3rd, 579. The state also provided the court with a secondary source from the Florida Jurisprudence, second edition, and that's going to be dealing with strategic decisions. And I'd just like to make one argument that's not really developed that much in the state's response, that when looking at whether to grant or deny this motion, the court should consider the credibility of the testimony of the witnesses here, and Florida Jurisprudence, second edition. It states reasonable strategic decisions of trial should not be second-guessed by a reviewing court when evaluating a claim of ineffective assistance of counsel. In addition, evidence that counsel's conduct was part of a deliberate tactical strategy that the defendant understood and approved almost always precludes the establishment of the deficient performance prong of an effective assistance claim. And trial counsel is not ineffective for strategic decisions that in hindsight did not work for the defendant's advantage, or that defense counsel's strategy was unsuccessful or resulted in a conviction does not mean the representation was inadequate. It further goes on to discuss, basically you have to show that in order to grant a motion that the attorneys, the defendant's attorney at the time acted so out of ordinary, out of the normal professional standard, that it would be egregious. And here we heard testimony that Mr. Chavans, he had a strategy. He talked about it with the defendant. The defendant never wanted to take the 10-year offer, although the defendant says he did. That's also that's going to be something for the judge to determine to weigh the credibility of the witnesses. Mr. Chavans had experience handling thousands of cases. Given the evidence that he was provided, he made a reasonable assessment of the case. There was a very high offer that was made, and I believe that Mr. Chavans advised Mr. McLaughlin in up to the professional standards and the professional norms, and just because that it didn't work out, shouldn't be second guessed. And Mr. McLaughlin did not complain once about his attorney until after the verdict. So I just asked the court to consider that. Thank you.
All right, thank you. I'll review it all and make a decision as soon as I can. Take it under advisement.
Thank you, Judge.
Okay.
Thank you, Your Honor.
Thank you.
All rise, please.